representing myself. I don't need a barcode to represent myself. What am I in here for? What charge am I on here for?
Buckle up, because what you're about to witness is absolutely wild. We've got two explosive courtroom cases today. First, a hit-and-run defendant who claims the KKK hacked his car using AI, blames conspiracy theories for his crimes, and insists he doesn't need a lawyer despite facing 5 years in prison. Then, we've got an assault case with strategic legal maneuvering that'll make your head spin. From defendants firing their attorneys to judges ordering competency evaluations against the defendant's will, this is courtroom drama at its finest. Will Joshua War convince the judge he's competent to represent himself? Can he really subpoena the entire Michigan Department of Corrections? And what happens when a defendant's conspiracy theories collide with the cold reality of felony charges? The tension is real, the stakes are high, and you won't believe how this unfolds. Let's dive straight into the chaos.
Let's do it. Where's Mr. Brown? Okay. And Ms. Constantine, you might want to move out of the way there.
Oh, sorry.
So, no, you can stay there if you want. Court does call the case, People versus Joshua Wara.
Trevor Mabel for the people here.
We are ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Wara. Mr. Wara, state your name for the record.
Joshua Wara.
All right. And this is a date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara.
Forensic evaluation for what? What's going on here?
Based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washington County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was
That is a
perfectly fine.
felony.
Hold on. Did he just say the Ku Klux Klan used an AI ethical hacking app to take his car for a joyride and break his glasses at the hospital? This is exactly why judges get concerned about competency. Look, claiming conspiracy theories involving hate groups and artificial intelligence while facing serious felony charges isn't just unusual. It's a massive red flag for any court. The judge is trying to protect War's constitutional rights here, but War keeps digging himself deeper by making these bizarre claims. He's got ADHD and PTSD, which he mentions, but that doesn't automatically disqualify someone from self-representation. The real question is, can he effectively defend himself when he's focusing on subpoenaing security guards from hospitals and mobile gas station footage instead of addressing the actual charges? Notice how the public defender wisely warns him that anything he says can be used against him, and he just keeps talking. This is a textbook example of why even innocent people need attorneys. What do you think? Is War making a strategic mistake by representing himself, or does he actually have a valid defense buried under all these conspiracy claims? Drop your thoughts in the comments.
Felony, that is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you,
All right,
Mr.
Count 2 on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm going to suggest to you this. That refrain from saying anything, because anything you say can be used.
Oh, I know. They used an AI ethical hacking app the tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent.
wanna
I said I'm
represent
representing
yourself?
myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to subpoena the camera footage from mobile gas station
now
on
knowing
Main.
what the
South
charges
Main.
are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the courtroom.
Yes, Your Honor, I
And
understand
would
that.
not be shown any favoritism.
Yes, and I would like to subpoena my discovery
If at
packet,
some point in
please.
time you wish then to be represented by counsel, you need to make that request to the court.
Okay. I've
to
tried
do
calling the
that.
public defender's office, and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet. And
Here's where things get really interesting from a legal standpoint. Judge Simpson just made a crucial decision. He's ordering a forensic evaluation despite War's insistence that he's competent. And you know what? The judge is absolutely right to do this. War keeps bringing up his GED from 2013, saying he completed it in 3 months as proof of his intelligence. But here's the thing. Competency isn't about intelligence. It's about whether you can understand the proceedings against you and assist in your own defense. The court has a constitutional obligation to ensure defendants are mentally fit to stand trial. This goes back to the landmark case Dusky v. United States, which established that competency requires both rational and factual understanding of the proceedings. War is talking about Neuralink cases, subpoenaing MDOC phone records, and requesting everyone's addresses, none of which relates to his hit-and-run charges. The judge sees someone who can't stay focused on the actual legal issues at hand. And that $25,000 cash bond? That's staying put until the competency hearing on January 29th. The public defender remains on the case whether War likes it or not, because the court's priority is protecting his rights, even from himself.
discovery packet, and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please.
All
And I would like,
cases
yep,
only
and I
have
would like to
one. You have
also
more than
subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARF level 4. And WCC pictures and
Sir, I listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm perfectly
your
fine,
own,
Mr.
sir?
Simpson.
Sir, for your own
I'm not on Social
protection and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic.
And sir, here's the
Investigate.
thing.
I do not
I
go
have
to the forensic center.
I have to, in terms of these proceedings, make sure that you are competent and
Oh, I'm very
no
competent,
link.
Cedric Simpson. You can tell. I'm very
Thank you, sir.
intelligent. I have a
You
GED.
named
I
that
got a
judge
GED in
GED.
2013 in 3 months.
Okay. All right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to
Well,
subpoena my GED from the
Here,
Adult
and you
Transitions
can
Program
do
in
that.
2013
You
at
can-
Washington
you can
Community
draft a
College.
subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the
Thank you. Yeah, that way,
Forensic
if you see I got a GED from WCC
I
in
am-
2013 in 3 months, you know I'm
Now,
competent.
this is how experienced legal representation makes all the difference. In complete contrast to our first case, watch how Attorney Constantino smoothly navigates this assault case. They've worked out a strategic deal. The defendant waives his preliminary examination on count 2 in exchange for dismissal of count 1, assault with intent to do great bodily harm. That's huge! That charge alone could carry serious prison time. Instead of forcing the prosecution to prove probable cause at a preliminary exam, they're making a calculated move. Counts 4 and 5, the misdemeanors automatically follow the felony. The defendant fully understands what he's giving up and what he's gaining. Notice the stark difference in how this proceeds compared to War's case. This defendant is calm, responds with yes ma'am and yes sir, and has clearly had extensive discussions with his attorney about strategy. The no contact order gets reinforced with warnings about third-party contact, and he acknowledges it without drama. This is professional legal defense in action. The question is, could War's case have gone this smoothly if he'd trusted his public defender from the start?
You know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025.
January 29.
a.m. I will sign an order to
Can you
that
give me a
effect
PR
at
bond,
this
please,
time.
Judge?
I'm sorry?
Can I please, I would like to request a PR bond.
This time you can file a motion, or somebody can file a motion before the court, and I'll consider a written motion, but at this time I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry, don't
I'd like to subpoena a bail bondsman phone
check
number.
with the individuals at the jail. I'm sure they'll be more than happy to assist you in that regard. All right. So that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a
Get
public
the
defender.
evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that. You may be right and come back competent, and then we can get this proceeding moving even quicker.
Not gonna come back, huh? Y'all gonna try to.
Your Honor, before we go off the record,
Y'all corrupt as it. Y'all fucked up, people. Y'all people fucked up.
Okay, keep moving. All right, been a pleasure.
I'm Benjamin Franklin's son.
Me too.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on, and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors who have in other cases can supply it directly to him.
Understood.
All right. Thank you.
Tina Costantino appearing with and on behalf of Mr. T. Mr. T, can you state your name for the record?
Michael T. Thank you. He's waving.
Yes, Your Honor. And there's, yes.
Can I stop you? No, go ahead.
I would stop here.
No, you wouldn't. Go ahead.
Your Honor, as I indicated to defense counsel this morning, while we are missing an important witness, this is a case where we would ask the court to be able to proceed under Section 6827C as well as people only.
Wow, what a stark contrast between these two cases. In Joshua War's case, we witnessed a defendant battling the court's efforts to protect him, insisting on self-representation while making conspiracy claims about AI, hacking, and the KKK. Judge Simpson made the right call, ordering a forensic evaluation scheduled for January 29, 2025, keeping the $25,000 cash bond in place, and maintaining the public defender on the case. War's hit-and-run charges carry up to 5 years in prison, and his refusal to focus on actual legal defense strategies instead of subpoenaing unrelated records could cost him dearly. Meanwhile, in the second case, we saw textbook legal strategy. Attorney Constantino negotiated dismissal of the most serious assault charge in exchange for waiving the preliminary examination, demonstrating exactly why experienced legal representation matters. The defendant walks away with significantly reduced charges and a clear path forward to his December 18th pretrial. These cases perfectly illustrate a fundamental truth about our justice system. You have the constitutional right to represent yourself, but that doesn't mean you should. The stakes are simply too high. If you found these courtroom cases as shocking and educational as we did, make sure to smash that like button. Share your thoughts in the comments about whether war should have accepted legal representation. And don't forget to subscribe for more jaw-dropping courtroom breakdowns. We analyze real cases, break down legal strategies, and bring you the drama that unfolds when defendants face the justice system. Hit that notification bell so you never miss our next upload.
Only on most accounts. So, Your Honor, if I may go through count 1, we would be able to proceed in such manner if the court allowed. Count 2 as well. Count 3, we would not be able to proceed today. So I'm sure counsel is going to ask for dismissal of that count. Count 4 and 5 are misdemeanors, so we would ask that those follow counts 1 and 2. Your Honor, that would have been our intent today, is to proceed under that authority. My understanding is that the defendant's going to waive on those counts.
So just so that I'm clear, he's waiving on 1 and 2, 3 is being dismissed, and 4 and 5 are following.
I thought 1 was being dismissed.
I'm sorry?
I thought 1 was being dismissed.
I'm sorry. Yes, Your Honor. Thank you. Count 1, Your Honor, even though we would be able to proceed if the court allowed under People versus Old Main statute cited, we would agree to dismiss count 1.
All right. So you're going to waive, he's waiving on count 2 with 4 and 5 following, right? Okay.
Yes, Judge, that would be correct. And if I could, I do need to.
Go ahead.
So my client and I, Mr. Teague and I, have discussed this. It's my understanding that he does understand that the people could proceed under the court rule on the assault with intent to do great bodily harm charge, the felonious assault, and the count 2 felonious assault, and that after full discussions that he is intending to waive his right to an exam. In exchange, the people would dismiss count 1, assault with intent to do great bodily harm. So the waiver would be with regards to count 2, felonious assault. We, the defense, would be moving for dismissal of count 3, felonious assault, as the people are unable to proceed on that charge. The 2 misdemeanors, of course, I've explained to him he does not have a right to have an exam in those matters, so those matters would follow. Is that correct, Mr. Teague?
Yes, ma'am.
Yes.
All right. You had an opportunity to have a full and fair discussion with your attorney regarding that. All right. Sir, along those terms, you're willing to waive your right to have a preliminary examination? Yes?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit on counts 2 and the misdemeanors following?
Yes, sir.
You understand that, sir?
Yes, sir.
People also waive their right. Yeah. All right. Preliminary examination having been waived. Defendant is bound over to circuit court on count 2 with 4 and 5 following.
Your Honor, with regards to the information, we would stand mute and waive a formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to counts 2, 4, and 5. Counts 1 and 3 being dismissed. Pretrial in this matter will be set for
December 18th at 1:30 with Judge Slay.
December 18th, 2025, 1:30 before Judge Slay.
Your Honor, if I may address one other thing.
Yes.
Your Honor, I want to make sure that at this point, it would essentially just be a warning. We're requesting from the court to defendant to make sure there's no contact with the victim. We also want to make sure that he understands that applies to other third parties.
All right.
And Your Honor, my client and I have discussed that today. He is aware, of course, of the no contact order. We've discussed. Sorry, got distracted by Officer Allen. Judge, we have discussed.
Feeling.
Yeah, it happens. We've discussed the no contact order. He understands that he cannot have contact not only with the complainant, but third parties, intending that contact to get back to or involve the complainant. So we have discussed that. It's my understanding he is aware of that. Is that correct, Mr. Teague?
Yes, ma'am.
All right. So, sir, you understand all of those terms in terms of the no contact?
It's no contact. It's no contact.
That's it. No contact. That means even through third parties. I will give you this ammunition. I'm sure she wouldn't care. You don't want that issue if it arises coming before me. I will tell you that Judge Slade does not tolerate that at all. So I'd suggest that you follow the advice of your counsel and make sure none of that occurs. Understood?
Yes, sir.
All right. Bond will continue.
Thank you very much,
you.
Judge. Have a good rest of your day.
It'll never end.